Mr. Dacey?
Good morning, Your Honor. This case involves an issue of collateral estoppel. On that issue, I'd be happy to take questions, but I am going to rely on our reply brief for the substance of my argument. I'd like to spend my argument addressing the central issue in this case, and that is whether Morrison Mahoney's 1995 partnership agreement violates Rule 5.6a of the Rules of Professional Conduct. Now, I'd like to begin by telling the Court why I think this case is not simply a rerun of this Court's prior decision in Pettengill against Morrison Mahoney.
Well, I suppose you're going to say because the provision in question has been completely changed.
Yes, I am going to say that.
Yes.
And I'm going to say that it's going to be completely changed in a way that we think is material to the present case.
But even with the change, doesn't it still sort of, at least indirectly, influence the, quote, pool of lawyers that might be available?
We think not. While the lawyer is sitting at Morrison Mahoney, he is available to clients. When the lawyer leaves Morrison Mahoney, he is still available to clients.
Minus his, whatever they're called, credits.
Partnership interest credits,
Yes.
Correct. But with that may mean that the lawyer, if he wants to go out and compete, has to give up the expectancy of receiving these APICs as a retirement benefit, which he would be eligible for if he stayed until he was age 60 or had served 20 years.
Clearly, if you had this in private industry, it wouldn't be a problem, right?
Absolutely not.
But do we treat lawyers differently?
In a very narrow respect. Under Rule 5.6a, it is prohibited to have an agreement that restricts the right of a partner to practice law after the partner terminates his relationship with the partnership. That specific provision was adopted in order to outlaw restrictive covenants for lawyers. Specifically, if you go back into the history of it, there's an old ABA opinion that deals with the question of whether it is ethical to have an agreement that says a lawyer can't compete for 2 years in the same county after the lawyer left the firm. That opinion was...
It's essentially, the original impetus, it seemed to me, was to make sure that if I want to retain you as my lawyer and you decide to leave the firm, you can't put too heavy a burden on...
Correct.
On me following you to someplace else.
Absolutely. That's exactly what a restrictive covenant would do. And the ethics opinion said it was unethical. It would prevent the client from following the lawyer. And it was codified in this rule.
In that regard, I'm wondering whether the Miller Arbitration Award or Mr. Miller's situation, you would, I know you argue in your reply brief, I think, that you think it's, for a variety of reasons, there was no appeal taken, even though you think it's wrong. But doesn't he actually present a closer question because he was over 60 and receiving retirement
Correct.
benefits and then practiced law and lost them?
Yes, it does present a closer question. It presents a quite different question because he was eligible to receive retirement benefits. He was
actually receiving them.
And he actually purported to retire, and he actually was receiving these APICS payments as retirement payments.
It's almost like a vesting. You know.
Well, there is a question of vesting here. If you actually go all through, serve all those years, and are eligible to receive it, is it fair to take for the firm to take it away? I don't believe that question is presented by the present case, because in the present case, none of the plaintiffs were 60 when they left the firm. None of them had served for 20 years. None of them were eligible to begin receiving these benefits.
Mr. Dacey, let me ask you this, and I'll ask Mr. Doniger the same question. There has been a huge change in the practice of law. And it used to be a sort of given that if you, first of all, that you stayed with the law firm until the end of your career, unless you went onto the bench or onto a general counsel's position or out of state or something like that. And second, that there was an expectation, because lawyers compensation wasn't very low, that it wasn't very high, that continued until your death. And there was a huge shift, I don't know whether you would agree with me, but somewhere around about the early 1990s, so a good chunk of time again, where it became clear that there was going to be a lot of going in and out. My sense was that that many mechanisms were put in place to allow present equity partners to themselves prepare for their own retirement. Am I correct about that?
Correct. That's the 401k plan is the most common.
But there are others, correct?
There are other forms of profit sharing and the like that are supposed to permit people to save for their own retirement. One of the problems that Morrison Mahoney faced here is they had a very old-fashioned unfunded retirement plan,
I think that was not unusual.
which was very common. And when they got into the mid-90s and they faced the problem that all firms were facing then, which is that unfunded liabilities are not good for the health of a law firm, they started the reform by cutting back on these apex benefits. But they also had a whole class of older partners who were not in a position to go out and right then begin salting away money in a 401k in sufficient amounts to ensure that they would have a good retirement. Those older partners had in effect relied on this retirement program. So the change they started to make was incremental. They started to address this problem of unfunded liabilities, but they left open the possibility of receiving these APICs because there's a reliance interest here. There are older partners who are expecting to receive this and are not in a position to go out and build up a big retirement nest egg. But that's a very common problem. Almost all law firms have been struggling with the issue of what do we do about future unfunded liabilities.
Just remind me, what are the ages of the plaintiffs here?
Well, I don't remember the exact age,
But I mean, more or less.
the oldest was Mr. Pierce, and he was in his late 50s, and the rest of them were all younger when they left.
Mr. Dacey, I take it that if a partner had retired, reached age 60, had practiced law with the firm for 20 years, reached age 60 and retired, and then subsequently, for instance, took a job with the government, or as I think at one point in your brief there's a suggestion that they went off and painted sunsets in Tahiti and made a fortune painting sunsets in Tahiti, that they would not be disqualified from receiving the APICs.
Correct.
So doesn't the situation here where the APICs are forfeited only when the retiring partner is actively involved in the private practice of law, doesn't that just collide head-on with the rule?
No, for two reasons. First off, if you have a retirement program, then Rule 5.6a has an exception. You can restrict the right of a partner to receive benefits as an incident of a receiving retirement benefits. So if you're over 60, or you've served as a partner for 20 years, and you meet the definition of retirement contained in the partnership agreement, you can receive benefits. The firm is permitted by the express language of the rule to impose some restrictions on that. The real case is what happens if you're not eligible and you're not prepared to retire within the meaning of the partnership agreement. In that case, you don't get your APICs, and it doesn't matter whether you go to Tahiti or whether you engage in the active practice of law or you go into public service.
So if a partner was entitled to his or her APICs
Yes.
and reached the magic age, whatever it is, 60 in the number of years, and then went off to practice law somewhere else, said, I'm retiring, I'm going off practice with another firm competing with you, they still get the APICs.
No, they would not get the APICs.
Why not?
Because under the partnership agreement, it says that if you return to the active practice of law after retiring at something other than the firm of Morrison Mahoney, you're not entitled to receive your payments.
That's Mr. Miller's case.
Pardon?
That's Mr. Miller's case.
That's Mr. Miller's case, and that's what the partnership agreement says, and that, I think, is expressly permitted by the exception, the last clause in Rule 5.6a.
That's not this case.
That's not this case. None of these people were eligible. And I would point out the firm has actually administered the benefits that way. One of the arbitrations it's gone through before it went through the arbitration with Mr. Miller was an arbitration with Mr. Moran. Mr. Moran wasn't eligible. He hadn't reached 60. He hadn't served as a partner for 20 years. I think he left to go into the insurance business. So he wasn't competing with the firm, but the firm said, you're just not eligible under our revised partnership agreement.
Well, do you agree that it would not be, it would at least be violative of Rule 5.6 in Mr. Miller's circumstances?
No, I don't, because the rule says that you can place restrictions as a condition of receiving retirement benefits.
If we disagree with you, do you agree that there's any severability provision within the interpretation of the rule?
That provision isn't raised in this case, is what you would say.
I'm saying that we don't even really have to address that issue. We think that Morrison Mahoney has a valid retirement program, but this case isn't about that because these partners never qualified in terms of age or years of service to receive those benefits.
So you're saying that the whole distinction is whether the partner is qualified under the terms of your plan. That's what makes the difference.
Correct.
So
There
we
are service requirements, age requirements, and there's a definition of retirement in the partnership agreement that you have to meet. You've got to meet all of those things to be entitled to receive benefits.
So the partner could practice law as long as it wasn't in competition,
In fact, the
whatever
firm,
that means.
well, it could mean a lot. This firm specializes in insurance practice.
So the
And-
partner could go out and be a real estate lawyer, probate lawyer.
You mean a retiring partner?
Yes.
Yes. What the partnership agreement says is that if you return to the active practice of law at something other than the firm, then you don't get your benefits. In practice, the firm has recognized that, for example, people who go off and represent the family business or the family trusts,
Or who could pay the minimum amount to go and work for the Attorney General or
or people who go to work for the Attorney General. They
What
haven't
about
been-
my example? What if they go out and join another firm in its real estate department and say, we're not, don't have a problem because you folks deal with insurance litigation?
As drafted, the partnership agreement says you've returned to the active practice. You go and look at the definition of retirement and see whether it fits within one of those categories. If it doesn't, you don't get your benefits.
That's really what happened to the plaintiffs in this case. They went out and practiced law. Well, they didn't otherwise meet the retirement.
Correct. They
But
were
if-
not 60.
Okay, if somebody meets all your requirements and goes out, I think what Justice Green is trying to say, and goes out and practices law somewhere else, then you're not going to pay that person his or her retirement benefits.
Correct. And we think that is expressly permitted by the exception to Rule 5.6a.
Which says what, again? What does that
That
exception
you
say?
cannot practice, you cannot enter into an agreement that restricts your right to practice law after termination of the relationship, except an agreement relating to retirement benefits.
Concerning benefits
Yes.
upon retirement.
Okay,
Benefits upon retirement, that's right.
right.
So and there's a good deal of case law around this. The
take it-
Boratech decision in New Jersey discusses this whole retirement benefits issue very thoroughly. The Newman decision down in the District of Columbia, and there is permitted some restriction.
Well,
on
you
competition.
don't dispute that loss of the APIC is a major financial disincentive, do you?
It's a major financial disincentive to leaving the firm. But every retirement benefit that has minimum age or service requirements and is at all generous is a disincentive to leaving the firm. If I have a retirement plan and I have to work till I'm age 60 in order to enjoy those benefits, then that's a disincentive for me leaving. If I have a profit-sharing plan and I have to be there 10 years in order to share in the profit-sharing plan, that's certainly a disincentive for me leaving after 9 years. There are a whole variety of different ways that firms try to give people incentives to stay.
So at least in this case, we don't even have to deal with the Rule 5.6 issue.
Well, I believe that it's not covered by Rule 5.6, because I believe that as written, there is no agreement that restricts their right to practice law after termination of the relationship.
And they wouldn't be eligible for retirement benefits because they're too young.
Correct. Basically, the way the amended agreement works with respect to partners who are voluntarily withdrawing from the firm, you settle up at the moment you leave the firm. You are entitled at the moment you leave the firm to receive your current year's income, and if you have a cash basis capital, you're entitled to receive that back, and then all bets are off. You receive no further benefits from the firm, and you have no obligations to the firm, so there is no agreement that restricts your right to practice after you leave.
Is there a severability provision in the retirement policy?
I believe there may be a severability provision in the partnership agreement, but I'd have to look again to be sure.
Thank you, Mr. Dacey.
You're welcome, Your Honor.
Mr. Doniger?
Thank you, Your Honor. May it please the Court. My clients are Mr. Pierce, Mr. Davis, and Judge Fahey, but the other two plaintiffs who are similarly situated to my clients, indeed precisely situated, have ceded their argument to me, so I will be arguing on behalf of
Mr. Doniger, let me ask you this. Your sort of, right out of the bat argument was that 5.6 protects the interests of clients and that the interests of clients will be impacted here.
Absolutely.
Let me just ask you this case. I retain you as my lawyer. You're at Sugarman Rogers, so I have no problem with the firm and I have no problem with you.
Yep.
Right? So you stay at Sugarman Rogers. And I
But-
keep you as my lawyer.
But, Your Honor, I say to myself, Sugarman Rogers has grown too big. I can't serve my clients cost effectively anymore. I want to start my own firm. I want to leave and serve these clients in a more cost effective and efficient way.
Yeah,
but if I do that,
Yeah, but all that says is then the lawyer can continue to pay you, or the lawyer might
client.
not say it's the client. It's too expensive. But what lies behind it, if you go to a firm like Sugarman and Rogers, it may be more expensive one day or next the other. You go to a two-person firm. I mean, you're now asking us to take into account and to essentially prohibit law firm partnerships from doing anything that impedes the lawyer moving from one firm to another.
Your Honor, this Court has already held that this agreement violates Rule 5.6.
But that's when it had its competitive piece to it.
No, Your Honor. Respectfully, it still has its competitive piece, because it is still the case under the amended agreement that my clients, the appellees here, can never receive their APEC accounts.
I understand that, but I cannot imagine that frankly, I mean, maybe I'm missing something here. Forget about Morrison, Mahoney, and Mill. I cannot imagine that a 24-year-old starts at a firm and then at age 34 leaves the firm, right? So retirement benefits might have vested because you have no access to retirement benefit. I mean, a vesting provision is different from a payout provision. So you leave at age 34. You then go right across the street. Not because it's any better. You just want to go across the street. They've offered you a better deal. It's got nothing to do with impact. And then at age 60, when the firm that the lawyer left, has become hugely successful because of various other things, or is teetering on the brink, you have to pay the 34-year-old? I can't believe that we can't recognize that that's a reasonable restriction to place on lawyers.
The restriction that we have to avoid is a restriction that imposes upon a lawyer a choice, a difficult choice.
Yeah, but you've given me a business-related reason. You haven't given me a shortage of lawyers-related. You haven't given me any reason. All you've given me is a cost reason so far.
Well, it can be all sorts of things. It's cost, it's efficiency. It's a lawyer who says, I can serve these clients better in a different environment. But if I move to that environment,
You might be
I
able
will
to
forfeit.
do that. You might be able to do that. But does that mean that 30 years later, the firm that you left owes you retirement benefits?
Well, respectfully, Your Honor, one thing we need to deal with, and I will in a moment, is whether this is a retirement benefit at all. And our position is it is not. And the position of this court has been, in the Pettengill case, that it is not a retirement benefit.
Why isn't the short answer to this case that these folks haven't vested, if that's the right word, they haven't done their 20 years or reached age 60? Why isn't that the short answer?
Because, Your Honor, the problem is that no one who competes with Morrison, Mahoney, and Miller, irrespective of whether they've been there for 20 years, irrespective of their age, no one can receive repayment of their APEP accounts.
But that isn't these plaintiffs, and how
I'm
can
sorry?
But that isn't these plaintiffs, so how can these plaintiffs raise the claim of some over 60-year-old person?
Because these plaintiffs, situated as they are, say to themselves, I have a choice to make. I can stay at this firm until I'm 60 and then leave and open up my own firm, but guess what? I still won't get my APEC account.
But then, tell us why you say this isn't a retirement benefit.
Well, I say it for a number of reasons. One, this court has held in Pettengill that it is not a retirement.
But the agreement's been substantially changed.
It has not been changed in that respect, Your Honor. And in fact, the original agreement always provided for the payment, the repayment of APEC accounts.
Yes, and this one doesn't.
On a current basis.
Right? And this one doesn't. Right?
No, it still does. It still does. If you were to look at section Article 7A2, it provides for the payment, the repayment of APEC accounts if there is a cash surplus on a current basis and if a majority of the firm chooses. And indeed, that is what's going on today.
You know,
As you-
Mr. Donegan, and I mean no insult, because this is a long time ago since I've practiced law, but there were a ton of agreements like that around this time. We used to refer to them as Polish coupons. I mean,
Polish?
well, in those, I'm saying, I mean no disrespect to it. That was a long time ago before the current Polish government. It was, you know, it was, if at a certain time in the future, and if you were still part of the firm had money, you could get paid.
But, Your Honor, this is not an expectancy. As this court held in the first Pettengill case, as the Miller arbitrator held, these APEC accounts are earnings that a partner has earned, but that they have been deferred. They are
Because of what?
because that is the way the firm capitalized itself. The firm, in effect, on an accrual basis, kept portions
Absolutely,
in there.
because they needed it to run, and that's my, as again, no disrespect, but they are something coupons.
Exactly. But that's very different from a retirement benefit. A retirement benefit, respectfully, is
That's exactly what retirement plans are designed to do, which is you don't have to pay out every single earning on a current basis.
It's kind of a quasi-retirement. I mean, if someone came into the firm at 24 and made partner at 32, then they would be vested at 52, would they not?
they would be vested immediately, Your Honor, in the following sense. If the firm decided by a majority vote that there was sufficient funds to repay the APEC accounts on a current basis, they would get paid. They would get paid their allocated
But
share.
clearly, at age 52, on that hypothetical, they could leave the firm. And
They
get
could
get
leave the
their
firm,
apex.
but if they competed, they would not get their
Oh, I
APEC
understand
account.
that.
Mr. Donaher, what if a lawyer comes into the firm at age 25 and becomes a partner,
Yep.
works until age 55,
Yep.
puts in 30 years,
Yep.
then goes to work for another firm,
Yep.
and retires at age 60? Are they eligible to get the pension from Morrison Mahoney?
Well, that's an interesting question, Your Honor. They are certainly disqualified. First, I take exception to calling it a pension. It's not. The question is, can they get repayment of their APEC accounts?
Yeah.
As soon as they go to work for that competing firm, they lose their right under this agreement. Indeed, there still is a forfeiture provision in this agreement that specifically says
That case isn't in front of us, and it seems to me you're trying to raise the rights of a lawyer in a kind of a third-party standing way that simply isn't here.
Well, Your Honor, the chilling effect of the forfeiture provisions in this agreement are such that even lawyers like my clients and like the other appellees who haven't been partners for 20 years or haven't reached age 60, in making the decision to serve their clients, how best to serve their clients,
Donaghy.
they are chilled by the fact that they know they can never.
They knew it when they signed the agreement.
Well,
mean,
whether
these are
they knew it
lawyers.
or not, Your Honor, the question is it an illegal agreement? I mean,
Mr. Donaghy, let me give you this example. And I'm way out of date with figures. And I don't mean to pick on you, but you're standing here. Tony Donaghy at Sugarman Lunches charges $500 an hour. There's some people who can't afford $500 an hour. So he wants to go and set up his own practice. And he says, I'll tell you what, I've got this pension to which I'm entitled. I'm going to go across the street. So the clients who are being charged $500 from Sugarman Lodges are funding me to represent you at $100. Your new, same client. Nice deal. So you've got client A, clients B, C, D, E, F, and G are now still being charged $500 by, your partner who's left behind because they didn't go with you. I mean, aren't you asking one set of clients to subsidize another set of clients?
no, Your Honor. I'm saying
Why not?
because the issue is whether this restriction,
Yeah, but if
In-
you go across the street,
yeah,
you can afford to charge less because either you don't want to earn as much because you've now earned enough, or because you've got a nice steady stream of income coming from the work that is now being performed and charged at rates that you used to charge by clients. So essentially, you can charge low rates.
if that were the case, Your Honor, then that would gut Rule 5.6 entirely. Because Rule 5.6 prevents agreements, partnership agreements, that impose burdens, that effectively act as a restriction on the ability of a lawyer to practice law. And a financial penalty,
Sure,
a forfeiture, is such a restriction. And the courts have held that. This court has held that.
If
in
we
Pettengill.
agree that this is either a pension plan or a quasi-pension plan, do you agree that you lose? I'm sure you're not going to, but...
Well, if what Your Honor is saying is that if this court were to hold, contrary to Pettengill, contrary to the terms of the partnership agreement, that this was a pure retirement benefit, then I would agree, because Rule 5.6, as Mr. Dacey rightly points out, has an exception for restrictions that pertain to retirement benefits. I say the retirement benefit, the classic retirement benefit, is what is provided for in this agreement, which is when you retire, you get 1 year's pay, an extra year's pay. That is a classic retirement benefit. It's put in the agreement in terms of 1 year's minimal annual
And
draw.
then I suppose the only other not alternative, but addition to that is you have a 401K or something like that if you want to have it, right? At the firm.
If you have a 401, that raises all sorts of other federal issues. I
know it, but you say the only retirement benefit is the 1 year pay, but all firms must have some sort of 401K program.
retirement accounts. I believe it would be illegal to say you forfeit a 401.
No, I'm not saying you forfeited it. You'd have a 401K. And
You could do.
That'd be your principal retirement
Exactly.
account.
But the APEC account here is, in effect, a capital account. It's the lawyer's interest in the equity of the firm.
I'm looking for 782 that you...
I miscited it. It's not 782, Your Honor. It's Article 4.
Okay.
Forgive me.
Is that 89 or 95?
Well, the 95 amendment doesn't change it.
Okay,
It's Article 4, Section E.
okay.
Now, in the amendment, the only thing that was changed in Article 4, Section E was a sentence that was put in. But at the beginning of Article 4, Section E is the provision that Apex can be paid out on a current basis. And that still remains in this partnership agreement.
So you disagree with Chief Justice Wilkins in his role as an arbitrator in the Moran case, who concluded that this was not a vested interest, it was merely an expectancy.
Your Honor, we don't know what was argued in the Moran case, such as it was. I mean, that is a fundamental difference between the Miller case, in which everyone here was present, everyone.
I'm just reading your brief. I mean, your reply, isn't this your reply brief?
No, that,
No,
Oh,
that's,
it's the other reply brief.
it's the other
Oh,
reply
so do you
brief.
disagree that he concluded that this was a vested interest?
I
It concluded it wasn't a vested interest?
I agree that,
difficulty that we have, Mr., even if these parties were there, and I'm not saying that you can, what do we do with an arbitrator making a decision, right?
an
I'm
arbitrator,
not asking whether this has got precedential value. I'm asking you,
Sure.
you disagree with Justice Wilkins' conclusion that this was a mere expectancy and not a vested interest?
we do disagree with that, and, the Moran, it's unclear how the Moran case was argued, whether Rule 5.6 was even argued. We don't know. We just have that two-page memorandum.
One problem here is a lot seems to turn on what label you stick on this so-called benefit.
Is it-
I mean, is it retirement? Is it an expectancy? Is it in the nature of deferred compensation?
Correct,
I mean, if
Your
it's
Honor.
deferred compensation, you've already earned it, and, it's past due money that you've
Well,
got to
And
get.
this court has already held
To Donica,
that it's not a retirement
here's the
benefit.
difficulty. You've already earned it. You've already earned it. But in fact, because you're a partner and you don't get a W-2, you also have to so even if I take your proposition that this was a capital account, the partners have to pay the capital account. The firm could be saying, pay up now, this is what we need, you're never going to get it back again. Right?
Right.
That's not what they're saying. That's not what this agreement
No,
does,
what
though.
they're saying is, we're gonna retain some of these for the capital account, and because we may do very, very well, we're gonna give it back to you, but then when you retire, because it is, in other words, it's not as if we'll give it back to you if and when we can afford to pay you, and if you're gone, too bad. That's a pretty harsh thing. In fact, there's a promise by the partnership to pay you back as a form of compensation in retirement,
As
right?
long as you don't compete with the firm.
Right.
Yes,
And that's the problem.
yes, because one way of looking at that is if you're going out there earning as much money as you need, why are we taking money from our capital account, from our current partners, to pay you?
But that penalty violates the public policy underlying Rule 5.6, and I see my time.
Thank you, Mr. Donovan.
Thank you.